So in the Government of Virgin Islands versus Riley case, we're looking at a provision from the federal rules of criminal procedure that allow for a deposition to be taken if the witness may be unavailable. And so through that, we're then asking the question of what does unavailable mean? And so the court then asks the question, what does unavailable mean with regard to the federal rules of evidence? Because obviously, with regard to this particular provision, we have an overlap between the federal rules of criminal procedure and the federal rules of evidence. The federal rules of criminal procedure, allow this deposition under terms that are then defined by the federal rules of evidence, and we're talking about live versus deposition testimony, and so clearly evidence rules are then at play. So when we look at then the definition of unavailability, there are 5 different provisions for this. One is if the witness would have a privilege, that the witness would be prevented from speaking because of attorney-client privilege, doctor-patient privilege. The Fifth Amendment privilege against self-incrimination would be one of the more common ones. Another reason for unavailability that would allow exceptions under Rule 804 to come in would be if the witness persists in refusing to testify. We've seen this previously in the case of the son who had testified against his father in an arson case, and then refused to do so at the subsequent federal prosecution, so they brought in the prior testimony. Refusal to testify, persistent refusal to testify, renders the person unavailable and makes their testimony now available under the exceptions under 804. If the person lacks memory, and we have seen this time and time again, if the witness is unable to remember, then all sorts of rules of evidence are triggered. We saw this under 801 D1A as an inconsistent statement. We saw this under 803.5 for the prior recollection recorded. And now we see if the witness is unable to remember, then all of the exceptions under 804 that require the witness's unavailability are now triggered. And so failure to remember really does open up the storehouse of prior testimony. And then the one that becomes an issue in the Riley case here, if the witness is unable to testify because of a physical or mental condition. And usually what we mean by that is the person is currently on a ventilator, or the person who was at one point sane is now insane. Typically we're talking about a change in condition, though in Riley, we're talking about kind of a novel application of this rule. We're saying in Riley that because the witness is young, it's a four-year-old who is going to testify against a defendant who is accused of killing the 4-year-old's father. And so the question then is the nature of a child's difficulty in testifying, the anxiety that testimony produces for a 4-year-old, does that constitute a then existing mental illness? Clearly not in the traditional sense. Clearly, you wouldn't say, oh, he's 4, therefore he is mentally infirm. That he's just young or she's just young. That's not what we typically mean by mental illness. But as we have seen with these rules of evidence, they are adapted to address the real concerns of courts in having these exceptions in the first place. They appear to be very policy driven. And so if you look at what the court says in this case, we're not asking whether this is actually a physical infirmity or not. We're asking if this is a reason, if we're offering a reason why we wouldn't have a viable ability to testify now, that the deposition testimony might just well be as good as it gets. And is there a rationale for saying that the deposition testimony is preferable to what we would get in court because the in-court testimony would be so bad? Do we have a basis? Is there some way we can shoehorn that into one of these rules? And courts have, as the Riley case notes, courts have said that age is actually a type of mental infirmity within the rationale for the rule. That the reason we have this rule is we are really asking the question of, do we find a reason why that the out-of-court testimony would be preferable to the in-court testimony that essentially cannot happen? And yes, because of youth. Is that kind of stretching the terms of this rule beyond the rules seeming obvious plain meaning? Yes. The policy justification, however, is we're asking, what is it that the rules are trying to achieve? They're trying to achieve the admission of testimony that cannot be meaningfully obtained otherwise. And because of this particular child's inability to testify, which is not that unusual for a 4-year-old, the deposition testimony is going to be far preferable to the live testimony, and the defendant's attorney had an opportunity to be present and to cross-examine the child. And so there are certain safeguards that are within that. This is a non-standard version of the rule. Key takeaway from this case, though, is that you have to show some basis for explaining why the person cannot now provide live in-person testimony. And in this case, the not complete inability, but why the person is substantially impaired in his or her ability to provide live in-person testimony. And can we find a category that fits that? And, again, this is creative, this is a stretch, but the court says that age, the anxiety that's produced by testimony, the testimony produces for the young, is a type of mental infirmity, and that satisfies this rule.